Thank you very much.
Good morning and welcome. Welcome to the fourth public stakeholders engagement meeting of the Special Select Committee of the Senate on the Sexual Offences Amendment Number 3 Bill 2021. This hearing will be broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. My name is Clarence Rambarat. I'm the chairman of this committee. I now invite the committee members who are with us to introduce themselves.
Good morning, everyone. I'm Ariel, a member of the committee.
Good morning, Roy Richards, member.
Thank you very much. Today we have three stakeholders who are before us and who have made written submissions. And these three stakeholders represent the Public Defender's Department, the Alliance for State Action to End Gender-Based Violence, and the Trinidad and Tobago Publishers and Broadcasters Association. I now invite these three entities to introduce themselves, the representatives, starting with the Chief Public Defender.
Good morning. Chief Public Defender.
Good morning. My name is Khadija Badu, and I'm a Public Defender 2 Junior at the Public Defender's Department.
Good morning. I am Raphael Morgan and I am the Deputy Public Defender.
Thank you. The representatives from the Alliance for State Action to End Gender-Based Violence.
I think Ms. Ince is muted.
Thank you. Good morning, Chair. Thank you. Members of the Select Committee, fellow stakeholders. I am Terry Ince, Founding Director of the CEDAW and Convener of the CEDAW Committee of Trinidad and Tobago, or CCOT. I'm partner in the Alliance for State Action, which is a network of organizations working on ending gender-based violence and human rights violations. The Alliance leverages law and policy analysis, gender-based violence services analysis, advocacy, and public communications. And we function on principles of mission, collaboration, consensus building, and commitment to human rights and social justice. There are several members of the Alliance with me, including Roberta Clark, Angelique Nixon, Sharon Herod, and others. And with the chair's permission, I'd like to pass it to the next speaker. Thank you.
Thank you. Would any other member of the Alliance want to introduce themselves?
Yes. Thank you, Mr. Chair. My name is Roberta Clark, and within the Alliance, I represent the Coalition Against Domestic Violence.
Thank you.
Good morning. Sharon, sorry. Hi, good morning, everyone. My name is Angelique Nixon, and I represent CAISO, Sex and Gender Justice, within the Alliance.
Thank you.
Thank you, Chair. Good morning, everyone. I'm Sharon Harford. I'm the Vice Chair of the Shelter for Battered Women and Children. Thank you for this opportunity.
Hi, good morning. I am Adiola Young, a member of the Caribbean Association for Feminist Research and Action, Trinidad and Tobago.
Thank you, Ms. Young.
Morning, Douglas Wilson from the Trinidad and Tobago Publishers and Broadcasters Association, Chief Director. I'm from the Trinidad Express newspapers. We have with us practicing journalist Suzanne Shepherd, who will identify herself on our behalf so that our position can be further articulated from that standpoint.
Okay.
Good morning. Good morning, Suzanne Shepherd, Lead Editor News Gathering at Guardian Media Limited, here today to represent the Publishers and Broadcasters Association.
Thank you very much. Do we have any other representative who has not introduced themselves? Okay, thank you. We also have, as part of the work of the committee, we have, of course, the Secretariat with us and representatives from the Criminal Justice Unit of the Ministry of the Attorney General, and also have other representatives from the AG's office, the AG's team. So I want to go straight into it, and we have the written submissions. And I want to start with the representatives from the Public Defender's Office, Department. Some of the things that you have at the end of your submission, you have made 11 recommendations. Some of them we have already engaged other members who have made, other stakeholders who have made written submissions, and I would identify those for you. On the matters, on the second item you've identified, which deals with the penalties, we've had several submissions on that already. And the other items, of course, we've had a lot of submissions on Section 22D and generally on Section 22. But I now invite you to take us through your recommendations, which you've made, with the exception of the penalties, which we've had submissions already. Thank you.
Okay, good morning. In relation to our first recommendation, we would ask, or we have asked that the sentencing aspect under the legislation incorporate a wider approach to sentencing in terms of allowing for the root cause of the deviant behavior to be identified and addressed. Whilst the current sentencing regime allows for deterrence, we do not see that the sentencing regime as prescribed will allow for the rehabilitation of offenders so as to curb the likelihood of the reoffending. So that we thought some sort of sentencing approach in relation to counseling or psychological intervention would be appropriate to be included in the legislation. That was in relation to our first recommendation. I understand that the committee has already been addressed in relation to our second, so we would move to the third recommendation. We spoke about the fact that there is a possibility of underreporting of this sort of voyeuristic behavior, especially as it relates to children. Section 22D addresses that, and again, I know that the Chair has said that the committee has been addressed in relation to Section 22D. We also asked that there's the incorporation of the law in relation to what they can call upskirting and downblousing. In the United Kingdom, they have recognized that offense. It's quite common, especially amongst children, whereby they use mirrors on stairs and they call it upskirting, or using cell phones to capture down the blouses of women, so that there can be some direct reference to those offenses, because there is a reference to technological equipment to commit some of these offences, but the equipment on a wider scale can include mirrors and that sort of thing. Furthermore, at number 5, we asked that in the scenarios whereby the offensive conduct has been defined to be where persons have, one second please. In section 22B, they establish categories whereby the offense can be committed, where one such category is for the purpose of causing humiliation, for causing distress, for obtaining sexual gratification, the threats for intending to cause a person to fear that the threat of sharing will be carried out, and the alteration of an image. We also suggested that, particularly in our society, they can also include the motivation, such as for to joke or to curse, because that is quite common in our society, and that will appear especially amongst the youth offenders, whereby there may not be, in their opinion, malicious intentions. You may find peers or younger persons stating that they would have taken the pictures or in situations or scenarios that were meant to be jokes, meant to be a source of humor, though not appropriate. It does exist in our jurisdiction. So that we did think that that was something to be considered under the legislation. We thought as well that in the jurisdiction of New South Wales in Australia, they categorized the offences within different, so there were base offences and aggravated offences. But one thing that stood out was that they all had the charges under their legislation being heard summarily. I think that that is something that we can consider, especially in relation to these sorts of crimes. We are all aware of the criminal justice system and the backlog within it. I don't think that it will be appropriate for persons to be waiting 10 plus years to have matters such as these be dealt with, especially in the circumstances where the orders for the material or the offending material to be destroyed come upon conviction. If we do not intervene at an early stage, that would mean 10 plus years whereby these materials exist and whereby persons are waiting for justice, and the harm will be continuing until that moment where an order is made for the material to be destroyed. So that I do think that the legislation can be amended to perhaps make it so that it is tried summarily, the offences are tried summarily, so as to allow the process of justice to take place at a faster rate than it is currently taking place in relation to having matters wait to be heard indictably at the High Court. Additionally, we thought that the consent, having looked at the New South Wales legislation again, they defined consent within the legislation. They inserted the instances when consent is deemed to be given and included provisions to protect persons who are underage. Of course, Section 22D within our legislation protects those persons, but we did not include or consider persons with limited mental capacity, or those who may have been threatened or coerced to give consent, or who may have been who may have given consent by way of unlawful detention. So that I do think that if we borrow from that piece of legislation and categorize consent, I think that it will make the legislation a lot more operational in keeping with that of the New South Wales jurisdiction. In relation to youth offenders, I know that our legislation provides for victims who are children, but we have not really addressed youth offenders at all. This is especially concerning as this whole concept of the taking and sharing of images of this nature is very common amongst the teenage age group. Those are persons under 18. Those persons in the New South Wales, they actually have a provision whereby if you're under 18 and you are considered an offender, before you are charged, that must be the Director of Public Prosecutions must give approval for those charges to give that sort of oversight of the process when it comes to youth offenders. Many times, youth offenders, the sort of justice or the sentencing process considered under this act is one whereby it's punitive, but we can consider a rehabilitative approach for youth offenders in these sort of circumstances. So that in New South Wales, there was a category of exemptions whereby consideration is given to the circumstances in which the images were taken, the nature and content of the image, the age, the intellectual capacity, vulnerability, and other relevant circumstances of the person depicted, and the degree to which the accused persons affect the privacy of the person depicted in the image. We are just saying that in considering youth offenders, we can perhaps ask that consideration be given to those sort of factors to determine if the conduct or the conduct complained of by the youth offender rises to that of criminal conduct. And furthermore, we ask that the sentencing approach under this legislation contemplate that offenders are likely to be persons under the age of 18 and to deal with them in a manner more suited to youth offenders, perhaps with looking at an approach that aligns with restorative justice. Again, we asked at point 10, we looked at the fact that authorized persons have not been defined within the legislation. Now, authorized persons are given the exception to their conduct being criminal under this legislation. However, authorized persons have been captured in a wide range of fields. There's the medical field, the forensic field, the scientific or educational fields. Take, for example, under the educational field, we may think an authorized person is a teacher, but in the present circumstances, that can extend to a lessons teacher, somebody you're doing virtual classes with. So that we are suggesting that either an authorized person be defined, or again, instead of giving the wide ranging exception to authorized persons, we go further and ask that the scenario of persons being exempted be looked at a little more deeply. And again, borrowing from the New South Wales legislation, they suggest that you look at the scenarios, the actual scenario of the image, the circumstances in which it was taken, the nature and the content of same, the circumstances of the person depicted in the image, that's the age, vulnerability, and other relevant considerations. That provision, without repeating it, can be found at page 36 of our written submission under the exceptions in the New South Wales legislation. So I do think that instead of giving that broad blanketed exemption, we can look at the scenarios a little more closely so as to prevent any abuses under the legislation. And again, we thought that was especially relevant because oftentimes for victims who are children, these sorts of crimes are perpetuated by persons who are closest to children and who have those sorts of relationships with children whereby there's some level of trust and authority over the child. Finally, we ask that the amendment would empower the court to penalize the offenders for any failures to comply with any orders given in furtherance of the Section 22D. That was what we consider to just basically be giving teeth to the legislation, whilst they have been, Section 22D allows the court to make the compensation order, the destruction order. We're asking as well that under that section, the court also be allowed to penalize anyone who does not comply with such orders given to ensure compliance.
Okay, thank you very much. I now want to invite the other members of the committee, my colleagues on the committee. If there is anyone who would like to ask a question or intervene.
Chair, yes, I have quite a few questions actually. Thank you, Chair. Through you, with respect to the consideration being given to offenders who are minors and the role of the DPP and the factors that mentioned would be relevant, do you think that the powers currently vested in the children's courts would be sufficient to address those concerns, or do you think that they don't go far enough and that the legislation needs to drill down more into how we treat with minors? Because I know the children's courts, judges and masters and so on who sit in that court now, they have a wide range of powers and things that they must consider with respect to sentencing.
Yes. In terms of the sentencing approach, I do know that the Children's Act allows for a lot more as compared to this Act. But in terms of the intervention of the DPP's office, we are suggesting that sometimes with youth offenders, the scenarios, when you dig deeper into what transpired or the events that transpired, they may not necessarily always rise to the level of criminal conduct. So we are asking that the DPP be given the requirement that he give the permission to charge in these circumstances, so that he will consider the scenario and whether it really rises to the level of criminal conduct. Just in circumstances, you might have two 13-year-olds. One offense is the taking of an image. When a 13-year-old takes an image of another 13-year-old, should that really rise to the level of criminal conduct in some circumstances? So we're asking, with those sorts of scenarios, the DPP should really be the one to review the file and make a determination, rather than charging the child carte blanche, and then before the court there's arguments and the child has already sort of been victimized too. Not to take away from the fact that a 13-year-old is a victim as well, but you don't want two victims at the end of the day. So we're just asking that he have some oversight in that process.
Do you think sorry, go ahead.
I apologize, committee member Lachmidial. If I may also add to that, there is precedent for this in the UK with the CPS, where they have underage offenders, where a specialized prosecutor reviews the file to see whether a charge ought to be laid.
Understood, but given the current resource constraints of that office, we're just looking at practicality as well. I know right now there's the practice of certain charges not being laid unless the DPP has review of a file. If you add all of these in law, and that's not in law, that's a practice. However, the police, when they require additional advice and support for non-capital offences, for example, they can approach the DPP's office. It's always open to them, but it's a practice. But so we have never actually legislated, or made it mandatory that the DPP gets involved in any type of matter, whether it's what we call the Romeo and Juliet type sexual offences and all of that. So for this particular, to put it into legislation is taking a step in a direction that we haven't gone there. The Constitution does vest in the DPP the power to take over matters and to, discontinue proceedings and so on. Do you feel that this would be opening up a door now of putting a lot more emphasis or a lot more responsibility on the DPP's office that they may not be in a position to? Because I'll tell you what happens when everything comes to the DPP's office for advice, it takes long, right? You understand that there would be a time delay, and that would segue into my next question about the time it takes to move through the system. So I just putting that out there for consideration, and perhaps you all could consider whether or not maybe some sort of review process within by the courts initially or something might be better as opposed to the DPP's office. But I take the point, and I see the point that you all are trying to make. Once a child is before the court, they are tainted, they've been arrested, they're in the system, and it may be that with the oversight of the DPP's office, it might have not even gone that way because of their input. My next question about time delays. You raised the issue of the amount of time. You made a recommendation with respect to dealing with matters summarily because of the time that it takes to get before a judge and the time that it would take to have the destruction orders being made. How do you all feel, or what is your view about some sort of interim proceedings similar to what you have in the civil court, like an injunction, but a magistrate or somebody being empowered at the start of these proceedings to make an order barring the dissemination of the material, whether it's a photograph taken without consent or shared without consent or whatever it is? Have you come across any jurisdiction that have empowered their criminal courts to make those types of orders? Because I tell you, for the length of it takes 15 years to get a judgment in the High Court now, and as a capital matter, far less with these matters which will go to the bottom of the judge's pile because people not in custody and all of that. And in that 15 years, the images that you have, that is the center of the accusation, could be shared about 6 million times. So have you come across any type of precedent for that, and how do you feel about that? As it's a sort of a more of a civil type remedy, but a judge or a magistrate being empowered to make that court order.
Let Ms. Bedo answer that one, and then I will.
Within our research, we did not come across any jurisdiction that gave that sort of interim remedy. The jurisdiction where we saw such remedies being given was the New South Wales jurisdiction, and they included the remedy like ours at the end of the proceedings for the destruction orders.
Right. Mr. Morgan, you wanted to add something?
Other than in quasi-criminal proceedings, if we consider the domestic violence legislation as such, there is a precedent for an interim order. So there is an ability to legislate for that. The difficulty would be with the standard of proof at that stage. What do we go with? Do we do balance of probabilities? It can be worked out. So I don't see any problem with the committee member's suggestion, and I do think it is a useful one in terms of preventing the dissemination, the damage being further caused during the length of the matter.
Okay. All right, I think that's it for now. I'll give way to Member Richards.
Member Richards.
Thank you, Chairman. Good morning again, everyone. To the Public Defenders Division, I have two questions. One scenario involves the dimension of children as you identified, and the other one does not. The first one is regarding your perspective on children are debarred from, of course, granting consent to sexual activity. We have the Romeo clause, etc., to deal with that. But how do you feel about having a clause or provision? Because very often, as Member Lachmedia said, and I think Ms. Bedo said, young people get involved in activity not necessarily for sexual gratification, but a group of them, and we've seen it before with these videos, unfortunately, where someone holds the camera while others are engaged in the activity as minors. And the person who's holding the camera has been given permission to film by the others, permission in parentheses, and so they're all captured in this, although that person may not be involved in the activity themselves and may be caught by the law, even in a scenario where a child's scenario is considered. What do you think about that, and what provisions should we put in place to deal with those sorts of scenarios, which are quite common, as we've seen in our youth, unfortunately, and it's not necessarily for sexual gratification. Unfortunately, it's for likes and popularity. That's one part.
Again, most of the questions will be answered by Ms. Bedo first, and I will supplement anything that she says.
Yes, that's why we consider the recommendations or the taking of the provision in New South Wales, whereby in terms of exempting persons, they asked for there to be a look into certain factors that I went through. So some of the factors would include the nature and content of the image, the circumstances in which the image was recorded or distributed, the factors such as age, intellectual capacity, vulnerability of the person depicted, the degree to which the accused person, so in this case would be the child's actions, affect the privacy of the person depicted, and the relationship between the accused person, so the child here, and the person or persons depicted in the image, so that in those circumstances where the intentions of the child was not necessarily malicious, or that as in the legislation, it may not have been for sexual gratification, we do think that a provision such as that, which allows for a closer examination of the scenario itself, may assist in determining whether such a child should be charged in the first place.
Thank you, because we have to protect them from themselves sometimes.
Yeah.
The other scenario involves something that I don't think has, I know it's not before the courts, and it's certainly in the public domain, whereby there's a video being circulated. Unfortunately, it reached my phone this weekend, where a woman is taping a man and a woman by a beach engaged in sexual activity. It's a really unfortunate video, and the woman is taping it in remonstration as to how disgusted she is by these two adults having sex in full view, and the woman's child is in the immediate vicinity. It's clearly in a public place. Yeah. And what happens is, while she's taping it, her child comes into frame and she says, look, my child is here. So there are several different unfortunate scenarios there. One, she may be taping it as evidence of a criminal act being taken place to provide evidence, but unwittingly she has included her child in the frame with the sexual activity, which adds a different dimension, and now the video is viral. So how do we reconcile that sort of situation where her intention is, from what I saw, I can't be taken, it's not sexual gratification. The intention is to document a breach, a criminal act, rooted in lascivious behavior, in the presence of a child, exposing a child to sexual content or sexual activity, which is another breach of the criminal code in Trinidad and Tobago. And now she herself, because she's recorded it, her child is in the frame and it has now been shared, may be found in breach of several parts of this law as proposed, even though it's in a public place.
So, just to clarify your question, Member Richards, the question is, how do we deal with a situation where someone may be taping someone else's sexual encounter, but not doing it for sexual gratification? How do you protect against situations like that?
Yeah, or even if it's and that's yes. How do you protect that person's intention? And I know intention is difficult in law. Or even someone who may have taped someone in the privacy of their home, in parentheses, but may feel that a crime is being committed. The person who's involved, maybe underage or something, but of course you may have breached the person's privacy, however you did it, but it's done with the intention of documenting what you think is a criminal act taking place.
Could I just jump in a little bit here? I think that, the fact of, so we have this exemption about preventing, detecting, investigating, or prosecuting a crime and legal proceedings. Well, I think I've given my view on legal proceedings and it being a bit wide. But what you do with the material that you record, if someone records a minor having sex inside of a house, and they choose to take it to the police, I can't see someone being captured here. If you decide to share it on social media, and even if you decide to share via WhatsApp or social media, two people having sex on the beach, then I think you would be captured by the intention to humiliate, as opposed to having the intention of detecting and preventing a crime. So I don't know, I'm not a defense attorney, but I would think that those are the issues that, and from a prosecutorial perspective, I think it's what you do with the recorded image that you may have to eventually, I think there. With respect to the child being present and exposed, and the parent not taking precautions and steps to protect the child from viewing what is taking place. That may be captured under a separate law and may give rise to other offences. So they may have unwittingly incriminated themselves under other pieces of legislation. But I think that what you do with the recorded material really has a lot to do with whether or not this law will protect you as a person trying to do something in the course of, criminal proceedings or preventing crime, as opposed to putting it out there. What we do have, and I would like the Public Defender's Office to jump in here. What we do have in this country, though, is a lot of people who take to social media to share things to embarrass law enforcement into action, and that's because we've seen women putting out videos saying, look, I'm showing their bruises, I'm being beaten up, the police not taking me seriously. We have people who say that they make reports all the time about minors being abused sexually or physically, and the police being unwilling to intervene. So they start recording it, neighbors start recording it and putting it on Facebook to embarrass the police. How do you think that those types of people whose intentions of sharing it is really to, prompt action, but can they be penalized under this law?
Unfortunately, to an extent, yes, because whilst part of their intent may be altruistic in terms of shaming the police into doing something, part of it also encompasses embarrassing the alleged perpetrator, causing them humiliation and societal, I guess, causing society to shun them. So unfortunately, those acts can be caught by the legislation, and it's a matter of how the prosecution wishes to proceed and whether they wish to charge and pursue the conviction against them. But the legislation is wide enough to capture those persons, and unfortunately, social justice warriors may be caught in the net.
So that's something I think we have to.
Yes, if I may, committee member Lakshmi Dayal, in addition to that, I think it goes back to the original point that we had been making, which is we really need to be very specific about how we put what in terms of getting out there, the nature of what is intended, and having that and in a little bit more specific terms. So for the person, as Member Richards would have pointed out, with respect to the sharing of the video at the beach, yes, it may have been out of one aspect of it, which would have been, anger, upset, the nature of all of it. But that's one aspect. But the minute that you go further and start sharing, you must know if you put that in a group chat, what is going to happen next. So there needs to be some level of where it stops, and I think that is what we're trying to protect in trying to say, okay, we're looking at the nature, where does it go and how does it go from there?
I think Member Richards' example is clear-cut, but let me give you another example of a real case that I dealt with, of a police officer who was involved with a 14-year-old schoolgirl. And, her parents kept making reports to the police station, many things, nothing was being done about it until someone who lived in the area videoed them drinking in a bar together and put it out there to shame the police. I mean, yes, it embarrassed the child, it embarrassed the officer, but it actually got him charged. So, do we then, so it really does have a gray area there that I suppose would depend on prosecutorial discretion.
And I think that's why I drew the example, because if I could, Chairman, about someone even filming within the confines of the privacy of their home who thinks that a crime is being committed, particularly against a minor or against an adult, that they don't think any other form of redress is going to bear fruit. So they tape it and may be caught by the law if they, as you said, if they share it publicly or as opposed to going to the police with the evidence.
Thank you very much, members. I want to know on this specific issue, which has engaged us, I want to now invite the Alliance and then the Publishers and Broadcasters Association on this specific issue. I want to say to the Alliance first that I've reviewed your written submission, we all have, and some of the aspects have been raised and canvassed before us already. And when I invite you to go through your submission, I would indicate those areas that we want to give priority to. But at this time, I want you to join in the discussion on this issue of, which you have raised in your submission, on this issue of sharing, the way in which the particular scenario raised by both Senators Richards and Lakshmi Dayal, those scenarios in relation to the submission you have made to us. And then I'll invite the Publishers and Broadcasters Association to also join on this matter, because in your submission, you have raised the issue of defining some of the media practitioners, and also asking that we draw the line between sharing and taking and sharing, and your responsibility to capture and share information that you consider to be in the public's interest. So first the Alliance, and then the Publishers and Broadcasters Association.
Thank you, Mr. Chairman, and again, good morning, members of the Special Select Committee. A number of issues were raised in that wonderful submission from the public defenders and the committee's response. So I'm not exactly sure to which ones you're speaking, but maybe I will respond to a few of them that I had some thoughts on, and also invite my colleagues to jump in if they so wish. On the scenario, for example, the taking of the video on the beach, or the taking of the video with the 14-year-old, as I understand it, under the offences which are being created or proposed to be created under this amendment, there are like three definitional elements of the offences. One is the nature of the image, that it is of a sexual nature. Secondly, that it is being taken or shared without consent, and that there's a particular motive for that. So whether sexual gratification or humiliation and causing distress. And as I read it, and I may be wrong, but as I read it, those three elements have to come together. So thinking about those three elements in the context of the woman taking the image of a sexual act in a public place, admittedly in a public place, but it is of a sexual nature. So that's one thing there, that we know that she's taken a photo of the sexual nature. We don't know what her motive is, but we certainly know that the likely consequence of taking and sharing that video is to cause humiliation and distress, and it is done without consent of the people. Although one can, I suppose, say if it's happening in the public space, you are impliedly given consent, but I don't think we can actually have that assumption in the context of what we're talking about, given the disproportionality between what is being done and the impact on the lives of the people whose images are being shared without their consent, because these things go into the universe for perpetuity and with infinite reach. So I think that the definition, the elements of the definition, I think can answer you, Senator Richards, to an extent. And I think that whatever was her motive when she was doing it, there's a foreseeable consequence. And so therefore I think that kind of conduct would run afoul, or should run afoul, of this legislation, and I think happily so. And similarly, with the 14-year-old, and something Senator Richards said about protecting children, I think really important. We understand, and maybe now to make a second point in relation to young people's children's behavior, because I think young people and children are a bit of a different basket. Young adolescents and minors, people under the age of, say, 16, who are engaged in a certain conduct because everybody has their phone. Children all have the phone to easily capture things. But I think in a sense we have to protect, we have to be ahead of the technology and ahead of children. So what I think that the legislation should be clear about is that the sharing of images into the internet space, and in any space, but certainly the internet space where it goes on, as I said, in perpetuity and in infinite reach, has to be something that almost like strict liability, that you cannot share images of minors, no matter whether they can, and they can't consent in any event. So I think that that's a policy decision which Parliament has to make, that Parliament is going to protect young people from that foreseeable harm that goes on for the rest of their life. It will color their entire lives. So that's what I want to say on that. On some of the really important points raised by the public defender, I think this legislation does have to think carefully and thoughtfully about how it treats with young people, with their evolving capacity, with their evolving sexuality, but also with the harm that's caused in non-consensual sharing. There's a reason why this Alliance for Gender-Based, State Action for Gender-Based Violence and Gender-Based Violence is engaged in this, because we do know that sexual offenses are disproportionately targeted against young girls and women, and then there's a particular vulnerability there. So the legislation actually has to acknowledge that in its content in very specific ways. One of the things, Mr. Chair, I want to go back to as I make that reference to the gendered reality of sexual harm here and everywhere in the world, is that we see that this legislation is written in a gender specific ways, not gender neutral, is very kind of masculinist way. And that may be the historic convention of drafting, but we're really asking and indeed demanding as equal citizens in this country that this practice of masculine includes feminine, he includes she when in fact it's the other way, male includes female when in fact it's the other way, man includes woman when in fact it's the other way in the sense of linguistically. We're really demanding that Parliament steps in to brings an end to this outdated and discriminatory practice. And in particular for legislation such as this, where the harms are so specific and one set of the population experiences them differentially and disproportionately. So that's what I have to say about maybe as a general point. In relation to children, we do agree with the Public Defender's Office that children have to be protected, but also children's evolving capacities have to be taken into account. I think in relation to criminalization, we are suggesting strongly that we stay away from criminalization of children as far as that is possible. And so we definitely like the Public Defender's recommendation that there perhaps be a screening process before criminal proceedings are commenced against minors. And that screening process should not only be done by the DPP, but we think definitely social services or, children's authority, an institution that has an understanding of children's evolving, children's sort of behavioral evolution and capacity evolution, so that we don't jump to punishment and criminalization in relation to children. We really want to endorse that point. And again, on the question of the process, as the process is initiated, in fact, the very first thing you want to do, particularly for children, is to protect them from the continued sharing of images. And so it seems to me you have to think that the legislation has to think through, one, whether or not it's possible to attach an injunction almost to an arrest or a charge, arrest warrant or a charge sheet, so that immediately you deal with you put a stop to the sharing. That could be one way that you deal with it. And I suppose it's almost like an interim order. I don't think in a particular way rights or the rights that may be affected to freedom of expression have to be balanced against harm done, particularly to children. So I think you can have something in the nature of an interim injunction ab initio to deal with, to interrupt the continued sharing, particularly of images of minors. That may be a kind of a solution there. And in any event, for all proceedings that are initiated, there should be a presumption that the images have to come down off the internet and have to be stopped shared. We have to be stopped sharing. Sharing has to be interrupted. I think that's also something that this legislation probably needs to think through. How would you insert that obligation to stop the sharing at the moment of charging? Because the harm, again, is so disproportionate to any right that may be curtailed by demanding that the sharing stops. We have other points to make, but I think my responses are to what I've heard from the Public Defender, and I don't know if the other colleagues want to join on that, on those points. We have other points to make.
Okay, maybe we could invite the Publishers and Broadcasters Association to make.
Can I just have one point, if I could, for the coalition? One of the recommendations they gave is for specifying a more serious criminal offense for adults who use children to gather sexual content. And I think I'd like Ms. Clark or her colleagues to expand on that a bit. I think it's a very good suggestion.
Member Richards, we would come back to their full submission.
Okay, fine, that's fine.
So I'm just going to the Publishers and Broadcasters Association on this specific issue which you raise and Member Vidal raised. And then we'd come back to the Alliance on their full submission. So Publishers and Broadcasters Association.
Okay, good. Thanks again for allowing us to be part of this session. On the specific issue of sharing of images, that is something that impacts directly on us in terms of the practice of journalism. In recent times, of course, the media, more than any other industry of late, has gone through quite an evolution that has been, of course, directly related to the emergence of social media, the development of social media. And we find ourselves dealing with some issues now that, say, even a decade or more ago would not have been a concern for us. On the specific issue of sharing images, we ourselves as media do find ourselves involuntarily, I may add, being the recipient quite often of a lot of images that may fall under the realm of this legislation, simply because very often when people are trying to shape the authorities, particularly I can cite that case that Member Richards referred to. One of their ports of call when they're trying to get action on an issue, or when they're trying to call attention to an issue, is that they directly go to the media, they directly share images with the media, they directly send to us information that they would like us to follow up on. It may not necessarily be a case where we ourselves are taking and sharing images, but very often in the practice of what we do now, we find ourselves being a recipient of images. Now, we, as I said, we will not, without following the normal practices of journalism, investigating, following up, and because we are also subject to other laws, certainly the Children's Authority Act and therefore things related to protecting minors, we would not necessarily fall into error in terms of being the ones who directly share such images, but we would be a recipient quite often, almost every day. We get those images. As soon as something is, by the time it is viral on social media, we ourselves have already been recipients of such images. The other concern we have is also how these kinds of activities also could have the effect of forcing some of our practitioners into a degree of self-censorship, in the sense of being concerned about possible criminalization of some things that we have been accustomed doing over many years in the process of investigating, particularly when we are doing deep investigative in-depth pieces. We are concerned about what certain vagueness in terms of what are the exemptions, if any, that exist for us in going about in the normal course of things. We have to, as we are investigating certain types of stories, we do store, we do collect, and not necessarily for the purposes of publishing or broadcasting, but we do often have to we receive certain information that we will collect and use as the basis for further investigation. I don't think that there's much more that I can add to that, but certainly we are directly impacted by those aspects of the bill.
Thank you. Thank you very much.
May I just add?
Yeah, go ahead.
Are you getting feedback? Yeah, I may just add that makes sense. The media is protected by existing laws in which it cannot publish material concerning minors, certainly minors being defined as below 18 years of age. So to the extent that minors are involved, so I think the media and the laws of Trinidad and Tobago already ensure that the issue raised by public defense in relation to youth offenders, that the media already has some provisions in place. So I just wanted to throw that in. The second thing I would like to throw into place with respect to the sharing from members of the public, and it really has to do with the totally blurred lines of social media versus the traditional mass media of radio, television, newspapers, in which you have professionals, journalist professionals at work in the discharge of their daily duties. What you do now have is the willy-nilly sharing of material into the public domain in a completely different manner, and how we choose, how we elect to treat with that. So whether it is a minor, 18 years and under, 18 years and under, so on. And all of these activities are now commonplace. How we treat with that, we don't particularly see media as having a difficulty because of the rules and the laws in place, but more of a definition of what has to happen society-wise because of all of the other nuisances that are there for regular members of the public to just post into social media. So my third contribution here now is in terms of solutions. We seem to want to legislate for it. And the one thing that we are not always looking at is the role of either the telecom in all of this, or the provider of the software platform, which is a ship. No different from how WhatsApp can already immediately identify that a particular image has been forwarded a sufficient number of times. They are always able to identify what images are and the nature of it. And to my mind, the legislation must include that the telecom or the platform provider, not the telecom, the software platform provider, has to have some level of culpability here. And the legislation is completely absent in that regard. Thank you.
I just want to invite the Alliance now. I will take you through your written submission in terms of the recommendations. I would highlight the areas I would like you to give priority to, and then you'd have the opportunity to highlight anything else in the submission. But on the first recommendation relating to the language used in the legislation, we've had submissions on that already, and we've taken note of what has been said. On the second submission relating to sexual gratification and consent, we've had several submissions on that, and we've taken note of the recommendations. The third one relating to coercion of the individual, we've also had submissions on that, as well as I've said before, the fourth on 22B, the taking and sharing of the intimate image without consent. The fifth submission and sixth submission, we've had a lot of discussions on those already, sharing of the intimate image and the recordings of a sexual nature. What I would invite you to make your submissions now on recommendations 7, 8, 9, on those submissions, and also the submissions you've made in relation to Section 20 of the Children Act, and you've made a note of the continuing and intentional failure to decriminalize same-sex intimacy between consenting children. We've noted that, and that is a matter that we take note of. But I would ask you now to address recommendation 7, 8, 9, and your comments on Section 20 of the Children Act.
Yes, thank you very much, Mr. Chair. Mr. Chair, just with your permission on the question of consent, which I note that you've said you've read the submission and you've also received other submissions on that. I just wanted maybe just to reiterate that the defining of consent, we think, is not just important for the clarity within the legislation, but it's also important for cultural change. The more we understand, in particular, socialize our young people into understanding what is consent, I think that that itself is about the transformation of the culture. And we do know that here, as many other parts of the world, that gender-based violence is a big issue across all age groups, but certainly amongst young people. So I think the definition will help with the sort of cultural awareness. And in relation to consent, also the legislation, they want to consider conditional consent. How does it deal with consent for taking and sharing under specific circumstances, but the sharing has happened outside of the specific consent given? I think that nuance perhaps needs to be addressed, and even more so having regard to the submissions made by the public defenders. I think Ms. Baidu spoke a lot about circumstances, and I think thinking about conditional consent and defining that may be helpful in filling out some of the gaps. In relation to the 7, 8, and 9, to which you have referred, I think 7 is the creation of a sexual offense of dissemination of unsolicited and unwelcome messages with sexually explicit content through emails and other personal messaging services. We have looked at Section 30 and the Offences Against the Person Act, which does address harassment, generally speaking, but we don't think this kind of harassment, which is around of a sexual nature, is covered under the Offences Against the Person Act. And so we're asking that should be criminalized. Persons who are receiving unsolicited messages of a sexual content experience being harassed. And in relation to the motivation could include causing humiliation and distress. It could be for sexual gratification. But like the public defender's submission, we are also asking for an expansion of factors of motivation to include, and public defender spoke about jokes. Of course, that's really very important as well, but also the motivation of exercising power and control, the motivation of harassment. So that expansion of what constitutes motivation, we think applies to 22A, 22B, but also applies to, if you do accept our submission, to create a new offense, so this kind of offense, that you're sharing unsolicited information with a certain motive or likely consequence in mind. So that's on 7. As I say, the Offences Against a Person has a general provision around the receipt of or the sharing of material, but it's not specific to material of a sexual nature, and we think it's really it's warranted. A specific offense is warranted here. On the 8, which is about the gender-responsive psychoeducation interventions, we think, the identification of harms caused is important, the criminalization of conduct is important, but we like the public defenders, are not only interested in punishment. We think that there has to be a lot of we call it interventions of a psychoeducational nature. In other words, we're trying to reshape culture that it could include rehabilitation, but really just let people understand what is the meaning of their actions. And many people do things kind of sort of without too much thought. It's part of the culture, what they're doing. And so we're thinking that part of the arsenal of the court, and we do agree on the summary jurisdiction as well, by the way, part of the arsenal of the court should be to order mandatory interventions for perpetrators of this kind of harm, gender-aware interventions, and also that those interventions must be particularly mandatory, if I can use that phrase, for minors, for persons under 18. Although we're saying that we should be very loath to charge minors, but we can use other approaches to interrupt sort of patterns of causing harm to self and others. So that's our gender responsive psychoeducation intervention. We say gender responsive because we do know a lot of the motivation around the sharing of images is connected to gendered considerations and reinforces gender stereotypes and gender harm. So we think it can't be just any psychoeducation intervention. It has to be very much aware of power dynamics which are contained within gender relations in our society. And so that's why we are there. On the number 9, which I think Senator Richards asked, and I do apologize to Senator Richards for not really responding to him. We're asking for an offense to be created which takes account of adults using children to capture materials, in which case the children themselves are being caused harm, and the persons who are being captured by children are being caused harm. So we think that that's a gap here in this, from how we can see it. That's a gap in the current amendments which should be filled. Causing a child to take images should be also criminalized. We also want to say, we talk about taking and sharing, but there are instances where images are being copied, not taken, in the sense that we understand that word. So we're suggesting that the line of words include taking, copying, sharing, to take into account where someone is maybe taking material off someone's phone or someone's laptop and sharing it. It's not, I think it's more like a copy. So it's more technical drafting issue, I think. We also wanted to speak about homeowners, and I think, Mr. Chairman, you've said that has been addressed. But so homeowners, you're exempt from prosecution if you've been taking video for the purposes of security, monitoring your premises. And we're saying that if that's the case, then people who come into the house should know that cameras are on. And then we do think that the legislation does not sufficiently disaggregate the taking from the sharing. So the taking, prosecution for taking, there's immunity for that if you're taking it for purposes of security, but should there also not be more specificity around the circumstances under which images taken can be shared for the purposes of security or monitoring? So we're asking for that to be a bit fleshed out, that you can only share for security purposes and share with police, for example, if you have taken images in your home. We think that needs to be made clear, not only under Section 22B, but also under 22A and 22B as well. I would like to ask my colleague to speak to the issue of the Sexual Offences, the Children Act, and the Romeo and Juliet clause. With your leave, Mr. Chairman, if I can ask my colleague, Ms. Nixon, to speak to that.
Should I go?
Yes,
okay,
go ahead.
Great. Thank you so much. So we want to highlight with great disappointment that in amending the Sexual Offences Act, there have been no proposed amendments to Section 20 under the Children's Act, which decriminalize sexual activity between children under certain conditions, including that they are not of the same sex. And so we want to highlight that this is a continuing and really intentional failure to decriminalize same-sex intimacy between consenting children and young adults, and that this continues a pattern of discrimination based on sexual orientation, which has been held to be unconstitutional in Trinidad and Tobago, and therefore is in violation of international human rights law. And so we really want to encourage the committee to consider this. I know perhaps we might mention the Jones appeal in process, but we still think this is an opportunity to correct this issue, which continues to criminalize young people's consensual sex acts when they are of the same sex. And to that point, we also want to highlight some of the whole of society and state response issues we've been calling for to prevent gender-based violence. And a part of that is comprehensive sex education, among a number of other trainings, gender sensitization, and really emphasizing what the Alliance for State Action to End GBV has been really calling on the government since early 2020, that we need to activate a whole of society and state response to these issues. And so happy to share more about that if there is time. Thank you so much.
Okay, thank you very much. I now want to invite my colleagues, Senator Richards and Senator Lakshmi Dial, to make their interventions.
Paul, I'll give way.
The only other thing I wanted to identify in terms of the submission so far to the TTPBA, and you're hearing me, right? And I don't know if you could proffer some solutions. I think Mr. Wilson referenced it earlier on, and in our interface with Matt, and also when we were in the JSC dealing with the cybercrime legislation, there was quite a bit of conversation about how these types of laws should seek to protect media practice in the country, as is enshrined in the Constitution, while at the same time offering the protections that the proposed legislation seeks to provide. And how we move forward, because it's come up over and over and over. And as a media practitioner myself, I've had, being part of the TTPBA and also having interface with Matt, it has escaped us in terms of having a defined solution to protect media work as well as to protect members of the public in various circumstances, particularly as the internet environment evolves, and we know it's evolving all the time. And what the suggestion is from the TTPBA in terms of trying to cleave out that protection in a realm where media practitioners are no longer domiciled in specific media houses, but are doing good work on blogs, and in some instances, individual practitioners. And I don't know what the TTPBA's proposed solution is for that, if there's one at all, and how we can move forward in terms of trying to find common ground and balancing the laws as well as the protections.
Okay. Our solution is really to ensure that the legislation identifies specifically, instead of merely implicitly, that journalists are covered. So, for example, the legislation, the bill, I should say, sorry, is clearly identifying that for purposes of police work or work with an attorney or work with a medical doctor who, in the discharge of their duties, are all needing to see, share, forward, seek further advice, etc. And in those contexts, there is no offense, but it merely states that unless it is for public interest, And we need to elevate journalism into one of the stated professions, exempted in the discharge of their duty from having created it.
In terms of your intervention there, and yes, police service is governed by the Police Service Act. The challenge that has come up over and over in a legislative sense is the definition of a journalist in the present context, and the evolving definition of a journalist, and the evolving definition of, we know, the theory of in the public interest. But how do we codify that?
Can I ask Sharon Suzanne to take that? Okay.
Certainly it needs to be codified, Paul, I agree with you. And certainly the line really there needs to be a clear definition, interpretation of what the practice of journalism is, as compared to what at one time was broadly defined as citizen journalism and activism. And we do know that because of how social media has evolved right now, there are certainly some individuals as well as some independent organizations that do not fall under the definition of traditional media, who are now unfortunately falling into that category, who are now sometimes, when they do not have the filters we generally apply in reporting on issues on the basis of our training. They do not have that. They do not, for example, have a knowledge or any training in defamation laws. And that is where we often run into problems.
If I can, or safeguards in place. Yeah. For example, in your position where if a junior journalist or reporter is sent, because sometimes it's not solicited by the journalist or the practitioner. The practitioners are known in the public domain as media practitioners, and because they are part of the fourth estate, they are sent information that the public feels is seeking to uncover wrong, or seeking to identify a perceived wrong. And it comes to the junior journalist's phone, and it is the duty of the junior journalist to send it to you. That encompasses sharing. It is your duty also to keep it and store it for possible litigation later on in terms of libel and slander. Am I not correct? As part of your internal mechanism and safeguards. And that is not always the case outside. So how do we reconcile those evolving scenarios and protect media practice, one, but also seek to protect public as this law is trying to do? And that is where the great question lies.
Yeah, that's a great question. And you know, one of the challenges we have right now is even one of the bigger laws that governs how we practice journalism. Certain sections of the Libel and Defamation Act mean that we are still vulnerable to criminal liability. And that has been further complicated by the fact that this particular legislation now borrows quite liberally in these specific matters of voyeurism and revenge porn. They borrow quite liberally from elements of the cybercrime bill that never saw the light of day. But you know, that intersection is where we now face a particular peril in even doing the normal practice of journalism. And as I can tell you, as a practicing newspaper editor who assigns people, there is hardly a day that goes by when I am not dealing, particularly in terms of junior reporters and I can assure you that we do guide them, we do subject our staff to training and interventions quite regularly. Right now we are looking at some of the things that have to do with another issue we have, which is time stamping content we already have, as well as watermarking content that we legitimately share on our social media platforms, as opposed to the things that are that are done by hackers and others. But I think in terms of legislative cover, our biggest challenge right now is that we are governed by a legislation that is more than 170 years old. Specifically that Section 8, Section 9 was repealed, but we are still faced with that peril. And it means that there are things that we will do legitimately in the course of building a story. I want to point out that what goes out there, what you see published and broadcast, is the final thing when we sift out all the things that are not relevant or legitimate or legal.
Susan, if I can interrupt, we is not homogeneous.
Yeah.
We doesn't apply to all present aspects of media. The we is not what we knew as media 20 years ago, 10 years ago, or even 2 years ago. So that we is not a homogeneous group that is not subject to the rigors that you would have been trained in. But it's no less important to the public.
Yes, because we now
and more importantly, no less accessible to the public.
So we have a situation now, as I said, there's not the filter. There are things in terms of how we portray children. There are things in terms of how we approach issues of privacy. There are things in terms of how we present certain information. There are things we will not put out there as responsible media houses. That is getting into the public domain now, under the broad cover of journalism by other entities and organizations, independent and otherwise, who are, of course, getting into social media. It is easier now. Back 20 years ago, as you yourself would know, it was not that easy to put up a broadcast. It was not that easy to put out a publication unless you had significant amounts of money and resources to invest in equipment and channels for broadcast. Now that has changed. It is as simple as getting your phone or your other device and putting it out there through your social media accounts. And there's where we have a particular problem.
And allow me to just join in here. Yeah. And that is the codifying that you seek to define. And clearly, the persons who are members of the public, who wish to be doing such activities of taking images and broadcasting and rebroadcasting, clearly, if they intend to, they need to belong to an association. If it is that it is happening only at a level where it is one image here, one image next year, versus, of course, if it is a routine part of what it is, the entity is engaging in, meaning on a daily basis also. So the codifying comes from A, you need to belong to the association. B, the association then has its rules, its regulations, and which govern its members. Will that stop it?
In other words, protection is not unlimited to anyone who can publish something, post something.
Well, and the person who is doing it singly, one here today and one here tomorrow, it will never cover someone like that.
I know the chairman is itching because we could go on with this forever. This probably needs its own GSC.
Can I just, so I think that we've gotten the point that regulation of the media, which is a whole other conversation, is something that perhaps needs to happen here. Now, let me go on the other side here. We have an exemption of things, defense that can be raised if something is done in the public interest. I, for one, found that to be exceptionally wide, and in piloting the bill, the Attorney General said that the reason that it was put there is for the media. As we say, media now has many meanings, and I think that some of the concerns being raised, there's a scenario you painted there of a junior journalist getting something and being obligated to share it with their editors and so on, whether or not they would be captured as committing an offense. But I don't know that creating an exception for persons defined as media when it is essentially an unregulated industry that will be serving the interests of the people who are victims. And at the end of the day, that's the primary goal of the legislation. So how do you balance the rights of the media versus the rights of the victims? Because when everybody with a phone is media now. Everybody with a Facebook page anonymously created with no name. And sometimes we find, and I found myself the victim of that, publishing things that are posted on Facebook pages by nameless people and fake accounts. And I mean, it is really, where do you draw the line? The protection of victims, particularly. And you say, yes, you have these codes of conduct and all of that governs you, but it doesn't govern everybody. So if we have to create a stronger defense for the media, then we are automatically, by doing so in this bill, creating stronger defenses for everybody who passes as media now. And that people are accepting as, because you have a regular Friday night show with a webcam, you become media. And that really, in essence, that's the purpose of this legislation, is to criminalize actions driven by sexual gratification, humiliation, and invasions of privacy, and causing of distress. And I think that any, legitimate media practitioners ought to have a sense of what that is and to stay clear of it. So I don't know that widening the definitions and creating of greater or stronger defenses for people in the media is necessary. In fact, I objected to the inclusion of public interest because I thought it was far too wide. What is in the public interest? Is it in the public interest to know that a person in public life is doing X or Y and Z in the privacy of their home? A lot of people will say, yes, they need to know that. They need to know about your marital business. They need to, things like that. And video and photographs make it more believable. So then where do you draw the line? So I don't know that at this point in time, given the state of the industry, I've read some of the concerns, and I guess I could segue directly into it. You all have said that you find that the bill is too vague in terms of the, press freedom and so on. There's no absolute right to press freedom as opposed to individual rights. And the line of privacy of the individual. How does the media see itself being disadvantaged by this law when essentially it is criminalizing private acts and private things that happen in the private space? I think that we need to get a little more explanation about that. And as opposed to defining media practitioner, well, I think we've covered that, and we know that is something that needs to be addressed in a whole other forum. And also, you asked about the interaction with the cybercrime bill. Well, that's not it has been brought up, but we can't really address all those concerns here. But I would be willing to hear some of your concerns on cybercrime and the definitions of on digital sharing by digital means and so on. And then you asked for a greater definition or tightening up of the language with respect to intimate image. Again, I think that we can't define everything in law. And I think what do you foresee as the difficulty for the media in terms of understanding what is an intimate image as opposed to what isn't, based on the current definition? So I'd want to hear you on that a little bit more, if I could ask about that. And, in terms of the public, well, I've said that already. In terms of anything that happens in the public view is, if you dress a particular way or conduct yourself a particular way in public, I think the expectation of privacy doesn't arise. And so the media would obviously be, to my understanding of the law and how it operates, protected to some extent with things that take place in the public. So if you could address us on the cybercrime issue and the definition of intimate image particularly, I want to hear you all on that.
In terms of the cybercrime legislation, and this is a conversation we have been having probably going way back to 2014, the concerns expressed then are the same concerns we do have now, in that the legislation in a way criminalizes some of the day-to-day practices of journalists It certainly does in terms of collecting information, gathering images and other things. Our concern is there is now an additional risk to which journalists and other individuals and organizations who function in the public interest are now exposed in the conduct of their legitimate duties. The bill, we think, because we do not have the same let me make sure I get the term right, a public interest exemption as applies to, for example, law enforcement, forensics, and other individuals. We are now exposed under this particular bill in the practice of what we do. I also wanted to emphasize that yes, there is now a broad range of people who claim to be media. I don't think that it is really all that hard to draw a line between practicing journalists such as myself and those who can fall in just for the, set up a Facebook page and so on and so forth. I think, however, for the purposes of that bill, that we would like to see in terms of a specific definition. This and other bills that affect how we practice things, that definition is clearly made. In terms of intimate images and in terms of invasion of privacy, we already operate and respect laws of privacy. But let's consider, for example, the particular context, and it's probably something that I can explain. Right now, we are in what would have normally been Carnival Week. We would have been covering right now. We are not really. We have a very scaled down version of Carnival taking place right now. But even in terms of covering Carnival and festivals of that nature, there are sometimes images. We could be running a video in a Juve setting, in a fete setting, in a parade of the band setting that can very broadly put us in the place of being accused of taking images, intimate images that are of a nature that is criminalized under this law.
But all of those, things that you've identified. So wouldn't you agree then that and again, I keep saying that what this bill is dealing with, and this is why I don't understand some of the concerns that the media are bringing forward. What this bill is covering is things that are happening in private, not in our public space. And it's you must have a specific intent. So you can't be accused or charged with voyeurism unless your specific intention is sexual gratification, causing distress, etc. Taking an image without consent. Again, if you're in a public place, there's implied consent, and sharing an image that's without consent that may have been taken with consent. Well, again, I think that carnival events it doesn't really create an issue here. I mean, it came up with other stakeholders because of the level of partial nudity and so on that we see taking place, but I don't foresee a situation. I cannot see a situation where someone in the media could be charged for, let's say, taking an image of a masquerader scantily clad and behaving a particular way on the Savannah stage. I mean, I just think it's highly improbable and unrealistic. And I mean, we have to trust that those that are applying this law and interpreting it would not go so far as to go behind the intention of the law, and that certainly isn't the intention of the law. Is not to criminalize taking footage of carnival events. It's something entirely different. So I hear your concerns with respect to the practices that the media may have to undertake in order to gather information. If it is done, again, what's ethical and unethical practices, to me is, well defined and known, but and there's certain practices that may amount to cybercrime which would just be illegal regardless of the we draw a line in terms of how far you can go in the course of investigative journalism. But when it comes to things like these of a sexual nature, I think that line is pretty clear. And I think that what can be shared and what should be published and what should be obtained by means of video recording or photographs, once that public interest requirement is met, I think that the defenses are there. If you ask to be specified in the way that medical and educational and law enforcement and so on are specified, you run into the problem that you have correctly identified of you all are not defined. You understand? So how do we define you when you yourself as a body, as a body of persons engaged in this, you all are not defined. So it may be a bit of a roadblock to advancing what I think is very important legislation if we have to stop and say, well, how do we define media? I'm not saying it's not necessary to define going forward. I would 100% support that, regulating, as I would say, media practitioners and so on. But it may be a roadblock to this legislation if we have to figure out how to define media first and who is going to enjoy a defense and exemption from certain things under this piece of legislation. So that's just my final comment on that.
Certainly, intent, we understand the intent of the law. Our concern really has to do with, and particularly because we are operating right now in a rapidly and constantly evolving scenario, the interpretations which could end up making us fall afoul of one or other provisions of this amendment. Right?
Okay.
When our own intent.
Thank you very much. I want to invite the three stakeholders who are before us to make their closing submissions now, starting with the Publishers and Broadcasters Association, and then the Public Defenders, and then Alliance. Thank you very much.
Thank you for the opportunity. I think we have been able to state our positions and participate in some other discussions here. I believe the closing comments from Senator Lachmidial have hit the nail on the head in relation to where it is we need to go, and we certainly can look at that. The clarity we need, though, is, I believe, can be formed through the TTPBA and how we register, and that being a requirement, persons who need to, or entities which seek to call themselves journalists or media, and we ought not to be broad brushing everyone as part of the media because that they're on social media. I think the legislation perhaps then needs to be tighter on the persons or entities not so registered through the TTPBA.
Thank you.
My closing comments.
Thank you. Public Defender.
Yes. Firstly, we'd just like to say thank you for the opportunity for allowing us to give our feedback in relation to this bill. Our written comment was a lot longer and more comprehensive than the presentation today. But just to reiterate some of the points, we do hope that there is some provision made for youth offenders within the legislation. And we're also hopeful that in consideration of the penalties that there's the net is broadened or widened so as to allow the intervention or the psychological intervention so that we can really have some progress in terms of just getting to the root cause of these sorts of offenses. And we also ask that there be some consideration to the fact that the rate or the time of which the process will take to get it to trial, that there be some consideration as to having the offences heard summarily so as to allow for justice to be done in a timely manner for offences such as these. But of course, we rely on our written comments, which are a lot more comprehensive. Thank you.
And the Alliance? Thank you.
Terry, you're muted.
Yeah, sorry. Thank you. So thank you again. So while CCOT contributed to the submission by the Alliance, which includes the 10 specific recommendations, CCOT also wants to take this opportunity to thank the Select Committee for allowing us to give these, make these comments and make this submission. We want to also take the opportunity to amplify our advocacy for any policies and laws that may be in line with human rights instruments such as CEDAW, which is the Convention for the Elimination of All Forms of Discrimination Against Women, and its principles of equality, non-discrimination, and state obligation. To that point, as a signatory to CEDAW, Trinidad and Tobago submitted a report to the CEDAW Committee in Geneva in 2016 as a lead-up to the country's mandatory review. Following that review in 2016, the CEDAW Committee made specific recommendations to the state that included references to the Offences Act, the Sexual Offences Act of 1986. Under General Recommendation 21C, the committee stated, as a matter of priority, adopt regulations for the Sexual Offences Act of 1986 to introduce sexual offenders registry with a view to combating gender-based violence against women by tracking recidivists. The Sexual Offenders Amendment Bill of 2019 provides for, among other things, the establishment of a sexual offenders registry, which will make it mandatory for adults convicted of sex crimes to be listed. This bill was passed, as you know, in January of 2020. So we note the effort to go beyond the above recommendation and address more recent form of violence against women and girls via the use of technology, social media in 22A, B, and C. But we do not aim to repeat recommendations previously made by other stakeholders, but we urge the drafters of this legislation to make full use of the human rights instruments in the drafting of the legislation, including clearly articulating the process for convicted offenders being placed on and removed from the Sexual Offenders Registry. Thank you.
Mr. Chair, with your leave, can I just reiterate 4 points? Yes. Thank you, Mr. Chair. We just wanted to, again, thank you for the possibility, the Alliance, for appearing before you. And again, I find myself endorsing the public defender's submission time and time again. And I very much like the idea of getting to the root cause. So 4 points we want to reiterate. One, we need a larger definition of motive beyond sexual gratification and humiliation and distress to include coercion, control, power and control. And we know that's a big part of the use of images in the context of domestic violence. We would like that language of definition to be expanded, that we should be not focused only on punishment, but also on cultural change and rehabilitation. And that this legislation needs to focus on children in particular and the decriminalization of children rather than the criminalization of children and that psychosocial intervention. So we think that the amendments need to pay a little bit more attention to that, as well as provisions for the removal of content in real time and not pending the ending of a criminal prosecution process, which, as we know, can take quite a long time. So we're calling for urgent relief. And finally, as we said in our submission, we also think that the focus on private-public may obscure the harm being done, experienced by many in what we think of as a public sphere. I don't know, Mr. Chair, but you can see all over Trinidad and Tobago, people are bathing under standpipes in this country, in the public space. So I think it's to say that this is just about private space, I think doesn't necessarily take into account the realities of the countries and communities where people live so closely together. A lot of things are done in the hearing and the visuals of communities. And I think we also want to be protecting of that. So I don't think we want to overprivilege the private space. I think we also have to look at the public space, and what we're trying to get at is the harm. The mischief we're trying to get at is the harm being perpetrated against people who are engaging in life in a reasonable expectation of privacy. I just want to say, Mr. Chairman, I think that one of our ASA colleagues wants to make one last statement. If you can, if I can turn over to Ms. Adiola Young. Thank you very much, Mr. Chair.
Okay.
Hi, everyone. Just that I would like to add, in addition to the registry, there should be protocol for sex offender management, meaning that the assessment, treatment, supervision, and community notification be an integral part for re-entry into society. Sexual offenders management is key in monitoring and evaluating these strategies that the state has in preventing this type of offense.
Okay, thank you very much. Is there any other member of the Alliance who wants to make a closing comment?
I would. Thank you so much. I just want to reiterate that in our submission, we really prioritize survivors. And I would just really urge in our closing that we take into consideration the lived experiences of people who have been violated in any way, people who are survivors who have had this happen to them. What are the ways that this legislation continues to protect people, but also takes into consideration the real everyday experiences? So I just want to urge the committee to also look at our very important recommendations that we continue to call for. And we really call on everyone to think about gender-based violence as a whole of society problem, and that we need a full-scale approach to how we end it. And we have to think about the root causes of violence and prioritize survivors. Thank you so much.
Thank you very much. As we close, I want to thank the three stakeholders who have been before us today. They are the Public Defenders Department, the Alliance for State Action to End Gender-Based Violence, and the Publishers and Broadcasters Association. Among the Alliance, of course, are several constituent organizations, including the Coalition Against Domestic Violence and other representatives, the CEDAW Committee, the Shelter, Womantra, the Halfway House, CAFRA, and KAISO. I also want to thank the media covering the work of the committee. And thirdly, I want to thank the AG's team, and of course led by the Honorable AG himself, and representatives from the Criminal Justice Unit, the Law Reform, Legal Civil Services Unit, and other areas in the Ministry of the Attorney General and Legal Affairs. I want to thank the parliamentary staff, both the Secretariat who is here with us, and the broadcast team. And finally, I want to thank the viewing and listening audience. I want to say to those following the live broadcast and the rebroadcast that we've issued a call for public submissions. That call ended on Friday, 18th February. This morning, the committee agreed to extend the time to March 18th, 2022. So members of the public listening or viewing could still make submissions. We've had one submission so far, and you're welcome to make submissions. So those stakeholders who are before us today, and those who are not here, I would tell you that the committee has tried to reach some of the key stakeholders. We've not been able to reach all of them. So if you are a stakeholder with an interest in the work of the committee, you are welcome to make a written submission. Even after we close the public hearings, we would continue to review any written submissions as we work towards our deadline fixed by the Senate, which is March 31st, 2022, to complete our work. So thank you very much. This meeting is adjourned.
Thank you.